This show is sponsored in part by St. Germain Catering, a woman-owned business that is professional in every delicious detail. And Fairfax Social Sports, Northern Virginia's largest co-ed men's and women's adult sports league, with over 32,000 players who participate in flag football, softball, basketball, and other adult sports. And finally, the Ruddy Law Firm in Fairfax City, Virginia, a law firm that provides legal services in the fields of business, probate, estate planning, and elder law. Welcome to the Probate Nation. My name is Richard Ruddy, and I'm the moderator of How to Probate an Estate in Virginia. Probate is a process to transfer ownership of probate assets to the beneficiaries of a deceased person. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probate rides seem to never end. In the course of your probate journey, you will encounter easy tasks and difficult tasks, but tasks nonetheless that need to be addressed. One challenge that often arises in the course of probate is dealing with real estate. Our discussion today will touch on several of the key tasks that confront an executor when real estate is part of the estate passing to beneficiaries. We are pleased to have with us a distinguished panel of local attorneys with probate and real estate experience in dealing with real estate. Jim Boring is the senior partner in the law firm of Boring & Pilger in Vienna, specializing in taxes, business planning, estate planning, and estate administration. He is a fellow of the American College of Trust and Estates Attorneys and the American College of Tax Lawyers. Prior to entering into private practice over 40 years ago, he was on the staff of the Joint Committee on Taxation and a law clerk to the judges of the U.S. Court of Claims. Also joining us is Dick Boatwright, managing partner at the Manassas Law Group. Dick has practiced law for over 40 years and concentrates his practice in estate planning, estate administration, and in the complex property and support issues that arise in divorce. Dick is a member of the Virginia State Bar, the Prince William County Bar, and the Virginia Trial Lawyers Association. Please welcome Jim Boring and Dick Boatwright. Gentlemen, handling real estate and probate is often a surprisingly difficult and frustrating experience for a lay executor, someone who's been qualified to probate an estate. Let's begin with a very basic question, Dick. Tell us how real estate is titled, because that really comes into play when we start to talk about probating real estate.
Okay. Well, the starting point, the most simple example would be one individual owns the property. So one individual has been named on the deed, that is the instrument that would have created the ownership, that would be sole ownership. Second situation would be two or more persons own property jointly. The deed named two or more persons to own it jointly. And in that situation, we use the term tenants in common. They are tenants in common with reference to their ownership. If that deed also said that there will be a survivorship, the language common law right of survivorship might be used, then those tenants, two or more, are called joint tenants with common law right of survivorship. And then the other situation that arises is when a husband and wife own property. And most of the time, a majority of the time in Virginia, the deed when they would have acquired title would be a tenants by the entirety deed with common law right of survivorship. Similar to the joint situation, that is, there's going to be survivorship when one passes or predeceases the other, but they're also treated under the law as if they were one person for purposes of their ownership of the property.
Okay. So those titling issues are very, very relevant as we walk through the probate process. So Jim, as we talk about the basic situation we see frequently, a husband and wife own a house as tenants by the entirety. Husband dies first. Who owns the property at that point?
The property passes automatically on the death of the husband to the wife. So she becomes the sole owner of the real estate the moment of his death.
Okay, and that's because it's held tenants by the entirety.
With rights of survivorship, that is correct, yes.
So from a technical standpoint, it doesn't really pass through probate?
No, it does not.
Okay, so how do the land records know that this has taken place?
Well, there are several ways that can be done. One is if the will is recorded, that would prove the death. If the will is not recorded, you can file an affidavit of heirs. The other choice is really do absolutely nothing until the surviving spouse gets ready to sell real estate, at which time she or he would produce a death certificate to show that the first spouse had predeceased. Another way that can be done is a deed of affirmation. You could record a deed saying that this husband had died and the wife is the sole owner of the real estate.
So essentially putting a recordation.
Yeah, put on record,
so
yes.
the title people could see what was going on. So Dick, let's just talk about now the surviving spouse owns the property and she dies with no will. How does that real estate pass now that she has inherited from her husband?
In that situation, the General Assembly has made a will for her. The General Assembly has indicated that certain persons are going to be her heirs at law, based on their relationship to her. And so it's going to pass to her heirs at law. If she happens to have children, it will pass to her children as her heirs at law.
Okay.
And in terms of how that might be evidence on the records, if there has been a qualification on her estate, that is her non-real estate, her probate estate, then a list of heirs would have been prepared as a part of that probate process. It would be recorded. It would identify the heirs. If there's not been a qualification on her estate, that is her probate estate, then someone might have recorded a real estate affidavit, as Jim alluded to earlier, and that would be the evidence of the transfer of ownership.
Okay, and those list of heirs or affidavit of ownership, real estate affidavit, is what the title people are looking for to figure out as we go to closing, as we'll talk later in the program, who should actually sign the deed. So if the spouse, Dick, was to die with the will, having inherited the property from her husband previously, how would the property pass?
Well, then that spouse, the will typically indicate or identify the person or persons to whom she wishes the real estate to go. They are called devisees, and then, excuse me, the recording of the will among the land records in that jurisdiction becomes the evidence of that transfer of ownership.
Okay. Now, Jim, many of our families nowadays are blended. So you have a husband and wife who have kids from prior marriages, and now they marry, and someone dies intestate, as Dick was talked about. Tell us how that plays out if it turns out that we have an intestacy with the second spouse dying.
Well, again then, as Dick indicated, she has a will as set forth by the General Assembly. If she has children, the real estate will pass to her children. If there are children from the prior marriage, i.e. the first predeceased husband, then the surviving spouse would only get 1/3 and the children would get 2/3.
Okay, and that's by statute.
That is by statute. That is correct.
Okay. All right, so moving on to the topic of real estate being located either out in another county in Virginia or in another state. Jim, talk about how do you transfer that property to another county in Virginia?
Let's say, for example, the decedent dies in Fairfax, and he owns property in another jurisdiction, another county in Virginia. You would have to record, if there's a will, you would have to record the will in the jurisdiction where that real estate is located. If the decedent died without a will, then you would file a list of heirs in that county where the real estate was located. Now, if the decedent died with real estate outside of Virginia, then you would have to comply with the rules of the law of where the real estate is located. As, for example, if the decedent owned a condominium or a piece of property in Colorado, you would have to record the will in Colorado and probably have to do a very simplified form of ancillary. We call it ancillary administration.
Okay, very good. Property is inherited. Frequently, the property that's inherited might be rental property, and we got a tenant and they're paying rent. Okay, what happens with that rental arrangement?
Well, the rent, in effect, follows the property. So if the property is passing to the heir or heirs at law, then the rent also passes to the heir at law or heirs at law. If there's a will that's been recorded and the will names a devisee, then the devisee or devisees are going to be the recipients of the rent. So the rent follows the real estate.
And by devisee, you mean that the beneficiary that's named in the will will receive the property.
Correct.
So now, if the property has a mortgage, Jim, and it passes on to beneficiaries or devisees, what happens to the mortgage?
Well, the mortgage is a lien on the real estate, and the devisees are going to have to pay that in order to be able to get the property. If they don't pay it, then presumably the lender would foreclose and take the real estate back. So the devisees are going to have to pay that mortgage. Now, if you're dealing with a husband and wife situation, and both of them are jointly and severally liable on the note to the lender, each one of them is liable for one half of that debt. So the first person to die is going to have, his estate is going to be obligated to pay off one half of that debt.
Okay, that's important to know.
That is important, yes.
Now, so far we've been talking about real estate passing to beneficiaries either by will or by intestate succession. We've had no discussion so far about somehow some authority that the executor might have over the real estate. Jim, talk about the executor. Where does he come into play with the real estate?
The executor only has authority over the real estate if there's a will which grants the executor the power to deal with the real estate, i.e., typically you would incorporate the powers under Virginia, which gives the executor a power of sale, in which event the executor can exercise the power to sell the real estate if it's needed to administer the estate.
Okay, so there has to be a judgment made that we actually are going to need
There has to be a
those
reason to do it. That is correct.
Okay. Now, I mentioned, we were talking before the show about the fact that the executor's authority over real estate, or lack of authority, is really almost mentioned at the very beginning of the probate process when we make our first filing with the Commissioner of Accounts.
Well, you would file an inventory listing the assets of the probate estate. Included with the inventory, you will list real estate over which the executor has a power of sale. You will also list real estate over which the executor does not have a power of sale. And you will list real estate which is located in another jurisdiction.
Yes, that is correct. So turning now to the real estate, again, let's talk about some practical things. Houses burned down, okay? Properties passed to beneficiaries. Who's responsible for paying the fire insurance, or what does the executor do about that?
Well, it's important to find out what the status of the fire insurance is. That's the first thing. And so it's important to know whether is there fire insurance on the property. It's important to notify, if you find that there is fire insurance, notify the insurance carrier, let them know that the decedent owner has died. Is the property going to be occupied or not? That's really important to the insurance company, because very often the existing policy is likely to have a provision that will say if the property is not occupied for a period of time, then the policy is no longer in effect, or it may say that an additional premium has to be paid. So it's important to determine, is there coverage? Is the coverage adequate? There may be coverage, it may be determined to be inadequate, in which case the owners of the property, let's assume that the executor doesn't have any power yet, and the devisees, if there's a will, or the heirs at law, if there's no will, need to get increased coverage. What about the term of coverage? How long is the coverage going to last? It may not, it may be about to be up. So that's really important to take a look at.
Very much so. Now, the other thing would be, of course, is you know, the real estate's passed, but of course we have maybe an unoccupied piece of property if there's no tenants. What do we do about securing the property?
Well, the first thing probably is to determine if there are any perishables in the residence or on the property that need to be protected and removed. If there are, that needs to be done. Do the locks work? You know, is it possible for someone to get into the house? It needs to be secured so folks can't get into the house. A big factor is going to be whether or not anyone's going to be occupying the house. Very often, one of the heirs at law or one of the devisees, or perhaps more than one, are actually occupying the house. There's a degree of safety inherent in that. They're going to be looking after the house. But if it's not occupied, obviously you've got, as in the fire insurance situation, a lot more risk.
Of course, of course. Now, Jim, of course, we talk again about the property is passed on, and we still have to worry about, you know, do we need to have heat on during the wintertime to make sure the pipes don't freeze? You know, are there real estate taxes to be paid? And of course, we talked about the mortgages need to be paid and maintained. You know, how do we handle that?
Well, that has to be arranged and taken care of. If the executor has a power of sale, the executor can handle that. But the expenses of doing that belong to the devisees. So if the devisees are not all the same persons who take the real estate under the will, then the executor and those devisees that own the real estate have to work out some way to make sure that those things are paid.
And your property account for how that's done.
Account for that, that's correct.
Of course. Well, we're going to take a short break, and when we return, we will have a local real estate closing attorney join our panel to discuss the challenges in selling real estate inherited from a decedent. So we'll be right back. Welcome back. We have been talking with attorney Jim Boring and Dick Boatwright about dealing with real estate that is in the estate of a deceased person and is passing by probate or operation of law to the beneficiaries of the decedent. What if the beneficiary wants to sell the real estate, or the executor wants to sell the real estate as well? What challenges or steps need to be taken to make sure that sale goes smoothly? With us is a longtime Fairfax County attorney who concentrates his practice in real estate conveyance, settlements, and title matters. He is a former director of the Virginia Real Estate Attorneys League and has testified before the U.S. Congress, HUD, and the Virginia Legislature regarding consumer interest in the real estate matters, including the Federal Real Estate Settlement Procedures Act. Please welcome attorney Howard Vermeil. Howard, welcome.
Good afternoon.
So we've been talking about how property passes when someone dies, whether by will, they pass by will or by intestate succession. We're now getting ready to go to the closing table, and of course one of the first things we have to ask ourselves is who signs the deed? You know, because that's got to be a key question. Tell us a little bit about some of the challenges that you face in sort of figuring that out.
Richard, that's one of the initial challenges. Who's the owner of the property which is now going to be sold through the estate? I always endorse getting a title search before anyone starts the process of thinking about selling real estate. It's an inexpensive process. We're looking at maybe $150 out-of-pocket cost and the cost of sitting down with a real estate attorney to simply go over who is the proper person to sign, who actually owns the property. Issues that you often come up with, you may find recordings which the decedent did which no one knew about. Example, a transfer on death deed. It's a fairly new instrument, maybe 2 years ago in Virginia. And this is sort of a mini will or mini conveyance of property upon the death of the decedent. You may find that property is no longer in the estate. You've just finished recording a will or recording a list of heirs, and you find out that this has been transferred and passes to someone else.
Of course.
You may have a prior deed of gift. Often people come to me to do deeds of gift to add someone else to the property that they own with survivorship in case they were to pass. Once we do a quick tax analysis to make sure it's not going to have any capital gains impacts in the future, we often add a relative, add a parent, add a son, add a daughter. You'll have another person that takes on survivorship. Until a title search is done, we don't know this.
Of course. Now you mentioned something that's very interesting. I want to throw back to our state administration lawyers that, you know, getting the title search done early in the process of the state administration. Jim, Dick, do you guys find you do that?
Yes. Typically, we recommend that you get a title exam to determine exactly what the ownership is and if there are any liens against the real estate that need to be taken care of.
Well, that's a good point, because sometimes you may not know about mortgages and that stuff.
It could be mortgage, it could be a judgment, there could be a tax lien, could be a mechanic lien, there'll be all kinds of things you have to worry about.
So
they
that's,
need to be taken care of.
And that process makes things go much more smoothly when they makes it to Howard's office and he's getting ready to go to closing on a piece of property. Now, Howard, when we do the deed, what type of deeds do we normally expect to be given by the estate and or the beneficiaries?
Well, if a fiduciary is selling, for example, an executor, the normal deed one would expect is a special warranty deed, as opposed to a general. A general warranty deed says, I warrant the title to be good against any problems that arose while I own the property or whatever comes out of the past. Special warranty deed simply says, while I own the property, no problems arose, but we're not warranting might come out of the past. So that's a title company will insure typically what does come out of the past.
Okay.
One other point I'd just like to bring up.
Yes.
Often we have people who are multiple owners of property that are not cooperative. We're often going to have to file a partition suit. 2 days from now, I've got a trial between a brother and a sister. No reason why this property shouldn't have been simply sold, but the family could not cooperate, and we have to file a suit to force a sale. A partition suit can be simple as selling a subdivision house when it can't be subject to dividing up, Or if you're out in the country and you've got 45 acres of property, one with a house on it and 40 acres of timber, it might be a division of a line down the middle, or dividing the timber from the house to make a proper partition. So these are things that families may not cooperate, beneficiaries may not cooperate, and you have to do as well.
So partition suit really is a tool to get people to get this
correct.
case. So now, frequently people want to sell real estate quickly after someone's passed away, and so we do a title search. We figure out what's got to be done. We get things cleaned up, and they go ahead. And everybody cooperates, so there's no partition suits, and they go to closing 6 months after someone's died. At the closing table, what do you have to face there?
Well, in the old days, we would hold the proceeds for a year because Virginia provides for attacking a will or bringing an adverse action against a beneficiary or an estate. It can deal with taxes, many things that can be done within the first year. So they would hold the entire proceeds for a year. That evolved into getting a third-party bond where the third-party bond company would take responsibility if the circumstances look right. And more recently, the title insurance companies have taken on the bonding role. Typically, if you have a situation where a property is to be sold within a year and everything is regular, all the beneficiaries look okay and look cooperative, they will sign a personal indemnity to the title insurance company. And they'll charge a premium of about $2 per thousand based on the sales price, and will take the extra hazardous risk of something being brought up later. If something is brought up later, it may involve coming back against the parties. It may involve refunding of the share they walked away with, and it will involve attorney's fees as well. So this is just a risk the title company is willing to take. If it's a red flag situation where there actually is something which is out there saying someone's going to challenge this situation, then I would not ask a title company to take that responsibility on. We would in fact hold for a year.
Okay. So there is someone needs to be aware that the proceeds may not be available right away if you go to closing on a piece of property within a year after death.
That is correct.
Okay. You know, this entire conversation, you know, about real estate, you know, when we talked with Jim and Dick earlier, and then now we're talking about going to closing and how we close and the type of title count challenges, it's very complicated, you know, and a lot of people, I think, can be very, very misled as to what they can and cannot do. So I want to ask you guys to share some final thoughts. You know, I'll start with you, Jim. You know, things that you think people should be aware of, watch out for as we start to go about selling real estate or inheriting real estate and then trying to sell it down the road.
Well, the first thing is determine who is the owner of the real estate. And then you need to determine what the title is and make sure the title is free and clear, or if there are liens against the property, that you've made arrangements, make those liens taken care of.
Okay. Dick, how about you?
Yeah,
Some thoughts?
I just go back to the fire insurance we talked about early in the question of the status of the property. And it's going to be critical to know whether or not it's going to be occupied or not, because your risk are generally going to be less if it's occupied, unless you have a recalcitrant family member there. If it's not occupied, then you've really got a lot more burdens to undertake.
Okay. And Howard, how about you? Any sort of final thoughts from your perspective?
Once again, get everyone on board where there's more than one beneficiary. It's easy if we simply have a spouse of a deceased person wanting to sell the family residence, not an issue. If we have a son and a daughter, usually not an issue. But if there are multiple parties, multiple levels of generations inheriting, there's a lot of work to be done and a lot of research to be done to get everybody in a position where they can sell. And if it takes filing a suit to obtain the aid of a court of equity, that has to be done as well.
In the case of the multiple beneficiaries where there might be some issues, is that a good example, though, where you might suggest if there is an executor or administrator, to apply to court and get authority to go ahead and sell the property as a way to eliminate those problems? Well,
certainly if it looks like there'll be issues down the road, then you want to get everyone on board.
Okay, great. I want to thank our guests, Jim Boring and Dick Boatwright and Howard Bermeal, for taking the time to talk with us today. You know, dealing with real estate is whether it's being probated or not, presents challenges for the executor and the heirs who inherit the real estate. You know, your comments and your insights today, you know, really are very helpful for our viewers as they try to navigate these challenges and probate the estate of a loved one. So thank you very much, gentlemen.
Thank you.
We hope you found the information on dealing with real estate provided by our guest helpful. Dealing with the real estate, whether being probated or not, is a complicated undertaking. It presents special challenges both for the executor and the beneficiaries who inherited or will inherit the real estate. I come away from the discussion knowing that the following questions need to be answered right away. Who owns the real estate? And second, who is responsible for protecting and insuring the real estate going forward? And finally, who can sell the real estate? These are not easy questions to answer, so talk with your probate attorney early in the course of your probate journey. The last thing you want to do is find out the house you inherited or are probating as an executor was destroyed by fire, but it had no fire insurance, or that closing on the sale of real estate has to be delayed because of title issues. This brings us to the conclusion of our show today on dealing with real estate. Good luck as your journey through the Virginia countryside continues aboard the probate train. On behalf of myself and the entire Probate Nation, thank you for visiting with us.